Good evening and welcome. Tonight, Grays is proud and indeed honoured to welcome Stephanie Boyce, President of the Law Society of England and Wales, to this evening of Mixed Messes. We are grateful to the President for finding time in what must be an incredibly busy schedule to speak this evening on the issue of the rule of law. Stephanie Boyce is the sixth female, the first Black office holder, the first person of colour, and the second in-house solicitor in almost 50 years to become president of the Law Society. Admitted as a solicitor in 2002, the president possesses a wealth of experience in corporate governance, regulatory frameworks, and professional regulation. The President is a council member of the Law Society, representing the Women Lawyers Division, a former chair of the Strategic Litigation Group, and a member of the board of the Law Society, a solicitor member of the Joint Tribunal Service, and in addition to all of that, the President holds a number of statutory appointments with her local authority. The President has recently been appointed to the Independent Task Force, commissioned by Her Majesty's Treasury and the Department for Business, Energy and Industrial Strategy to boost socio-economic diversity at senior levels in UK financial and professional services. In 2020, the President was voted on to the Governance Hot 100 Board Influencer. In 2021, she was named in the Power List 100 Most Influential Black People in the UK. By any standards, a serious woman. We welcome her.
Thank you very much, Vice Treasurer, for that introduction. It is a pleasure and privilege to be here this evening to address you all. I am delighted to see so many of you all in the hall this evening, and even more pleased to know that there are many more watching virtually via the live stream. I understand that for most of you here today, this event is a qualifying session for student members and an opportunity to build on your knowledge of key areas of the law. You'll be pleased to know that I have chosen to tackle one of the meatiest topics there is in the law, and that is the rule of law itself. The key question I want to answer in my lecture today is whether there is an inherent tension between the political and legal elements of our Constitution. In many ways, tension is to be expected in a mature democracy, and it is a sign that the system is working. But this is an area that has become the subject of not inconsiderable controversy and debate in recent years, and which has been given particular life by the government's pursuit of a series of reforms to the legal and constitutional framework. There is a view held by some that political and legal institutions are increasingly being drawn into conflict in a way that is damaging to the United Kingdom. For example, a previous occupant of the office of Lord Chancellor claimed in a thought-provoking speech last year that the concept of the rule of law has been the victim of conceptual creep, which leaves it open to hijack from politically motivated interest. He claimed in particular that the effect of this conceptual creep has been to set up a false dichotomy between the rule of law and parliamentary supremacy itself. This is, of course, concerning, a very concerning allegation. And the rule of law is at the heart of what it means to be a lawyer, whether you are a solicitor, a barrister, a legal executive, or a member of the bench. Indeed, a requirement to uphold it at all times is written into the regulatory systems that governs both your profession and mine. And while the rule of law has political implications, being as it is the fundamental basis on which our liberal democracy and system of justice rest, it is right to expect that it should not be weaponized to serve purely partisan political ends. But despite this, the former Lord Chancellor clearly feels that there is no inherent antagonism between the rule of law and parliamentary supremacy. That will certainly come as a relief to many of us. Nonetheless, in his view, the relationship between the legal and political strands of the Constitution have been strained and contorted. It is partly for this reason that under him, the government began its constitutional reform programme. And this evening, I would like to explore the claim that this is the case. And to do so, we must start at the very beginning and answer the apparently simple question of what is the rule of law. So the rule of law will be a familiar concept to all of us in this room. And no doubt, we all have some idea of what concept represents both in abstract and in practical terms. Yet producing a comprehensive definition of the rule of law has proved to be a task that has eluded generations of legal theorists. Perhaps we should start with that great expounder of the British Constitution, A.V. Dicey. Dicey explained the rule of law with reference to three principles. The first is that no man is punishable or can be lawfully made to suffer in body or goods, except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. In other words, the legal system in a society based on the rule of law is defined by its clarity and its lack of arbitrariness. His second principle states that every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Put simply, the rule of law demands that everyone is considered equal in the eyes of the law, even those of wealth, privilege, and power. Dicey's third and final principle is more contestable. It holds that the rule of law requires that important liberties and rights be protected by judicial decisions. In other words, by the common law, rather than by particular statutes or written constitutions. Needless to say, this might not be an understanding that would be shared by many from outside of the British legal tradition. More recently, the former senior law lord, Lord Bingham, turned his hand to producing a more modern definition of the rule of law. Rather than 3 principles, Lord Bingham outlined 8 principles that he considered to be fundamental to the rule of law. These are: 1, the law should be accessible and predictable. 2, legal questions should be determined according to law, not by the exercise of discretion. 3, the law should apply equally to all except where objective differences justify differentiation. 4, ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose of which the powers were conferred, without exceeding the limits of such powers, and not unreasonably. 5, the law must afford adequate protection of fundamental human rights. 6, means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. 7, adjudicative procedures provided by the state should be fair. And 8, the state must comply with its obligations in international law as in national law. And since Lord Bingham quite literally wrote the book on the rule of law, we might consider the case to be closed. But there is still vibrant academic debate about the proper extent of the rule of law and the nature of its implications for legal practice, politics, and society as a whole. something that both Dicey and Lord Bingham agree on, however, is that the rule of law goes beyond the mere commandments of the law. Indeed, this is a view that is shared by most academics and jurists. Jeremy Waldron, for instance, draws a clear distinction between the rule of law, which is philosophical and legal ideal, and a rule of law, which is much more mundane, referring to a specific rule that is required by law. The question is it right to separate the abstract from the practical in this way when discussing the rule of law? I believe it is helpful to turn away from academic postulation for a moment and explore how the concept of the rule of law is understood on the ground by ordinary people with no legal training. We at the Law Society wanted to understand exactly how members of the public conceive of the rule of law and of the justice system more generally. So early last year, we commissioned independent external research to explore public attitudes on this topic and test how the ordinary person on the street's view compares to those of academics and legal professionals. The results were incredibly revealing. Public support for the rule of law is very high, with people expressing high degrees of trust in judges and lawyers and sharing the view that the courts underpin fair play. In follow-up polling, we found that 97% of adults in the United Kingdom agreed or strongly agreed with the statement that everyone should be treated equally under the law, and 94% agreed that it is important for the United Kingdom to be seen as a country which upholds the law. However, our research also revealed a key difference in the way the public understands the rule of law. Rather than seeing it as a matter of high principle, as Dicey and Bingham do, the public very clearly sees the law in terms of the rules of the game. And we can learn a lot from this mechanistic understanding of the rule of law. What matters to the public is not the principle, but the fact of the law being adhered to at all times. Everyone has a duty to follow the rules, and the public expects these rules to be properly applied to everyone. And going back to the question I posed at the very start of my talk, there is nothing in this to suggest that the rule of law and politics should ever need to come into conflict. It matters not how the law is made or what its content is, or what its content is, as long as it is properly enforced and followed by everyone. But this is not quite the full story. There is, in fact, a strong current of principle running through the public's perception of the rule of law. And this came across most strongly when we tested people's opinions of ouster clauses. While, of course, few had any idea what an ouster clause was at first, once explained, the reaction was largely one of horror at the idea of certain areas of law being removed from the jurisdiction of the courts. And what this tells me is that underpinning this rules-based approach to the law is a fundamental principle, and that is the principle of fair play. And while most of the time the public is happy to get on with respecting the rules of the game, whatever they may be, there is a very visceral reaction to anything which seems to represent a thing of these rules in favour of one person or group of people. So, does principles have a place in the rule of law, or is it all just about respecting the rules of the game? On the one hand, the rules-based approach that the public seems to endorse is attractive. It fits in neatly with our assumptions about the purpose of the judicial function in this country and how it fits in with the legislative and executive functions. However, Britain has a long and storied tradition of employing legal principles to defend key constitutional tenets and personal liberties, a tradition that seems to be endorsed by the public's desire to see fair play maintained. It is important that judges are able to refer to principles whether of the rule of law, of access to justice, or of core British liberties. Without them, our system would be prone to accidental injustice, in which our law produces outcomes that are fundamentally out of step with the shared assumptions and values that underpin it. The way our justice system employs legal principles is very different from, say, the kind of lofty constitutional musings you might find on the US Supreme Court. Rather than having to derive arguments of principle from a single body of higher law, namely the US Constitution. The principles that are employed in the legal system of England and Wales are embedded in the common law. Indeed, it allows our system to function without a body of higher law and to respond appropriately to cases that involve fundamental rights and liberties on which Parliament has not yet provided a definitive statement of the law in the form of statute. This is what Dicey meant by his third principle of the rule of law, and our legal system is all the stronger for it. Nonetheless, it is cases that turn on questions of principle that attract the most controversy. An obvious recent example is the case of Unison and versus the Lord Chancellor, the 2017 case that saw the order introducing fees for the Employment Tribunal quashed by the Supreme Court. This case saw the court decide that the fees violated the principles of access to justice, which the court held to be integral to the rule of law, by effectively blocking access to the tribunal to those without the means to pay the fees. The government claimed both at the time and since that this is a question of policy, not of law, and as such, not a decision in which the court should be intruding. But while setting fees is indeed a power that falls within the remit of the government, the court must act whenever a government decision threatens a principle as vital and as fundamental as the right of every British citizen to seek justice in the courts. And this was no legal invention. The right of access to justice is firmly embedded in our legal history. Go all the way back to 1297, when Magna Carta was put on the statute books, and this is clear. We will sell to no man. We will not deny or defer any man either justice or right, as Article 29 proudly proclaims. And that clause is another example of how the use of principle to reinterpret legislation helps ensure that our laws keep up with our constitutional ideals. Because on a plain reading of the language of Article 29, it is clear that some people, women, are clearly excluded from the protection it provides. But English law has evolved over the years to interpret references to man or men in our law as including women, and will evolve further to ensure no one is excluded based on their gender. By any measure, this is a fundamental rewriting of one of the foundational statutes of our law. But by employing principle in this way, our law is able to avoid the accidental injustice that would have arisen and which would have required an unenviable amount of effort from our Parliament to rectify in statute. Does this use of principle to reinterpret statute offend against the keystone of the British Constitution, the supremacy of the Crown in Parliament? I do not believe it does, because the principles that are being appealed to are not simply particular moral or particular preferences, on the validity of which perfectly reasonable people might legitimately disagree. The principles that are invoked in these kinds of cases, such as the rule of law, the right of access to justice, and equality before the law, are principles that are axiomatic to our Constitution. And since these principles are so firmly embedded into our political and legal systems, as well as the public consciousness, there is understandably a very strong presumption in the legal system that Parliament at all times intends to respect these principles. It would take very strong and unambiguous statutory language to convince the court that Parliament has ever decisively elected to reject our historic tradition of rights and liberties and disapply principles as fundamental as these. However, it is, of course, true that a court judgment involving a novel interpretation of a statute could lead to an outcome which Parliament had not intended. That this might occur is not a result of an attempt by judges to seize political authority from the elected Parliament, but simply because in hard cases it is not always clear how legislation ought to be interpreted, or what Parliament's intentions were in passing the legislation in question. Furthermore, another perfectly plausible scenario is one where Parliament's intentions in passing a statute are clear, but proper legal scrutiny of the statute in question reveals that it may not, in fact, give proper effect to those intentions in a particular case, or even in general. Again, the discrepancy between Parliament's intentions and the legal outcome is not a consequence of some political machinations on the part of the judiciary, but in this case, a result of unclear or defective drafting. And it may be, for example, that the legislation was drafted with a particular scenario in mind, but another unforeseen scenario has emerged, which changes the legal facts and therefore the effect the legislation has. But while the legal process of analysing and interpreting statute may on occasion lead to an outcome which is at odds with the intentions of Parliament, it is important to note that our legal system never creates political impasses in the way that, for example, the US system on occasion does. The UK judiciary is not some alternative bastion of authority which can block the wishes of the legislature. There is always a path that can be taken by Parliament or the government to ensure that its agenda is put into effect in a lawful way. In particular, even if a court interprets a statute in a way that Parliament disapproves of, it always remains open to Parliament to change the law and correct this discrepancy between intention and interpretation. And where the discrepancy has arisen as a result of ambiguity in the language of the statute, or as a result of the effect of unforeseen circumstances, such a correction would be relatively routine for Parliament to make. Parliament could even choose, if it wished, to legislate to remove from individuals what had been considered a fundamental right. For example, the right to a fair trial. The court would have to be thoroughly convinced that the statute does indeed convey this intention and give effect to it. But in theory, if the statute is sufficiently tightly drafted, a domestic court would be bound to enforce it. Thus, in this country, statutory interpretation poses no permanent threat to the supremacy of Parliament. Parliament might, on occasion, feel its will has been thwarted by a particular judgment, but this can always be overcome. In this country, we have no higher law that a court can use to effectively veto a legislative proposal. Parliament remains supreme. So this discussion about the supremacy of Parliament gives rise to another interesting question. If Parliament is indeed sovereign, as we have established, and its clear and unambiguous will as expressed in statute cannot be impugned, is it possible to criticise legislation that has been properly passed into law for being contrary to the rule of law? Well, if we take the view that the public seems to espouse, that the rule of law means nothing more or less than respecting the rules of the game, then the answer to this question is no. Parliament makes the rules, and under the rule of law, we are duty-bound to follow them. But as I mentioned earlier, under the surface of the public's view is in fact more nuanced than this. When asked whether it is right that Parliament can oust the jurisdiction of the courts in certain areas, the members of the public we spoke to found this suggestion horrifying. And this horror at the idea of ouster clauses suggests that in the public's mind, there are indeed very real limits on how a sovereign parliament should use its supremacy, a sort of unwritten rule, if you will, that lies under the surface of the written rules of the law. I think my view on the particular subject of ouster clauses reflects the view expressed in Lord Falk's independent review of administrative law, which considered this subject, amongst many others, in detail. And that is, the doctrine of parliamentary sovereignty means that Parliament has the power to legislate in such a way as to limit or exclude judicial review. The wisdom of taking such a course and the risk in doing so are different matters. Indeed, there should be highly cogent reasons for taking such an exceptional course. Clearly, it is possible to criticise legislation for failing to respect the spirit of the rule of law, while holding that Parliament has the right to legislate in any way it sees fit. The Law Society, as representative voice for the solicitor profession, has a duty to speak out when legislation threatens the ideals that are core to the rule of law. And in this vein, the Law Society has been vocal in outlining its opposition to proposed reforms to judicial review, which would serve to undermine the important function it plays in holding public authorities to account, a central tenet of the rule of law. Our main concern with the Judicial Review and Courts Bill that is currently before Parliament is the provision creating a statutory presumption that would direct courts in most cases to use new, untested, less complete remedy than an ordinary quashing order. And this presumption encroaches on judges' traditional discretion over the awarding of remedies. And this discretion is important to ensure that claimants who successfully challenge unlawful actions are able to receive an effective remedy for the harm they have suffered. The ultimate effect of the presumption would be to disadvantage claimants, while allowing the state to minimise the extent to which it will need to rectify its own mistakes. It is important that judicial review retains its teeth, as it is the primary way by which ordinary citizens can hold public authorities to account for actions that breach the law. And while those public authorities might complain that the scope of judicial review has expanded in recent years, the reality is that the scope of judicial review has expanded in response to expansion in the scope of public authority. Wherever the state extends its tentacles, the law must follow. And this is essential to our system of checks and balances, which ensures that those with power do not exceed their authority or the bounds of the law. Another area of contention is the Human Rights Act. The government has recently published proposals for reforming the Act and replacing it with a Bill of Rights. A consultation is currently underway, and there will be plenty of opportunity for lively debate in the months ahead on the merits and demerits of particular reform proposals. But it is important from the outset to be clear on what the Human Rights Act is and what it isn't. What the Act is a practical means of ensuring individuals can assert their rights at home in a UK court, thereby limiting the UK's liabilities to the European Court of Human Rights and reducing the number of cases that are taken to Strasbourg for resolution. While it is a statute of great constitutional significance, the Act was not a project to create something akin to a body of higher law in the American or continental legal traditions. Rather, its aim was to guarantee access to domestic courts for domestic litigants on human rights issues. By careful design, the Act does not restrict the supremacy of Parliament, as it does not allow for the striking down of primary legislation, nor has it created new legal obligations on the United Kingdom. The obligations the United Kingdom has as a signatory to the European Convention on Human Rights are obligations we have held since our accession to the Convention in 1953. The Human Rights Act only effect was to give the Convention direct effect in UK law. It is also important to recognise that it is perfectly compatible with parliamentary supremacy for the United Kingdom to be bound to international treaty obligations it has freely entered into. And indeed, Lord Bingham's 8th principle of the rule of law makes it clear that respecting our international law obligations is just as essential to the rule of law as respecting domestic law. Ultimately, the European Convention on Human Rights is an international instrument. It is not just about the United Kingdom and protecting rights here. It's about fostering consensus and ensuring countries across Europe afford the same respect to fundamental rights that are essential to a stable and law-based society. The participation and support of all the signatory countries, including the United Kingdom, gives it its strength. And while most threats to the rule of law might come in the form of legislative proposals, just as pernicious to the effect of attacks on the motives and reputations of those professionals whose job is to see that justice is done, the government is quite right to say that litigation should not be used as a continuation of politics by other means. Political considerations are not and should not be relevant determinations of law. But by the same token, politicians should not castigate judges for finding that the law does not fit with their political objectives or conflate lawyers' actions on behalf of their clients with support from the political views and motivations of those clients. Denigrating lawyers for doing their job undermines confidence in their essential constitutional role and risks dragging them into the political arena. Reasonable disagreement on the merits of a particular decision is unobjectionable, but we must take care to ensure that this does not spill over into heated criticism and personal attacks. On the other hand, the courts have no obligation to show undue deference to the government because it is Parliament that is sovereign, not the executive. The government must respect this distinction, for in the eyes of the court, the executive is no different to any other claimant or defendant. All are subject to the law, and it is the court's duty to adjudicate matters of law without fear or favour. At the outset of my speech, I posed the question of whether our Constitution sets up an inherent tension between the political framework and the legal one. Notwithstanding the former Lord Chancellor's concerns that the two frameworks are being drawn into conflict by nefarious actors, I hope I have shown today, this evening, that the two can and have coexisted constructively and that the conflict between them shows the system is working well. Indeed, while there can be tension, in many respects our unique legal system acts alongside our political system to avoid the deep pitfalls and harsh standoffs that afflict other equally sophisticated legal systems across the world and to assure a political and legal society which functions effectively. At the centre of this is a conception of the rule of law that is reflected in the public's attitude to the law, a conception that is a hybrid between a rules-based approach and a principle-based one. The British people's focus on respecting the rules of the game ensures an appropriate balance of political and legal authority. Our sovereign parliament makes the law, and the judiciary sees to it that it is applied equally to all. Yet underneath this rules-based approach is a clear seam of principle which can be best summarised as a collective, instinctive British belief in fair play. And this appreciation of principle is embedded in our common law and allows our law to adapt and evolve over time to ensure that the essential liberties that British citizens have come to enjoy and expect over hundreds of years remain central in the legal system. The application of key principles in the law is no challenge to parliamentary supremacy. Instead, it works alongside it, ensuring that the United Kingdom need have no recourse to higher law and written constitutions to protect those values we hold to be fundamental. From Magna Carta to the Bill of Rights to the Human Rights Act, our legal and political systems have worked together to protect and promote the rule of law in this country. It is an inheritance we should be proud of. We should do all we can to preserve this delicate balance for posterity. Thank you.
We are fortunate to learn that the President is willing to take questions. Just 5 minutes. Madam President.
Thank you very much. Yeah. You can ask me questions on anything you like.
Stand up.
Hi, I had an essay on this question. I was wondering what your views would be. I've done it, by the way, so it's been submitted. If the Human Rights Act were repealed, would traditional judicial review sufficiently protect our fundamental rights?
It's a good question, because, of course, we've got the review of judicial review coming at some point as well. We, of course, the Law Society says that, the Human Rights Act is such a carefully crafted piece of legislation that it is fine in its current state. There is no need to repeal it. What we do say, of course, is that there is a need for the public, greater understanding of this act amongst the public. So there is a greater need for public legal education. So we, of course, would continue to advocate for the Human Rights Act in its current form and encourage the government not to go any further. And if they do, we would suggest that there is a balance that should be struck in as much as tidying up, but not to go any further. But in terms of judicial review, I think it's going to be interesting to see. So I guess to answer your question, we're not working on the premise that the Human Rights Act is going to be repealed. And I think it's fair to say that perhaps we've not gone further than that to give that consideration, because our position is advocating for it to be kept. But of course, in terms of, and I think it would be, as I said and set out in my speech, I think it would be, a great loss if it was repealed. But of course, we work on the basis that it won't be repealed. But judicial review, again, is an important mechanism. It is there for the, for the citizen to be able to exercise their rights, to enable access to justice against public authorities. And again, if there is any tidying up of judicial review, it must be to protect those rights, preserve those rights, not to take away from them. So I probably haven't answered your question. I've probably gone around the house in respect of it. But as I say, we work from the premise that it shouldn't be repealed in the first place. And we will continue to advocate for that exact position.
Thank you. I very much enjoyed hearing your talk tonight, so thank you for that. We have discussed the boundary between politics and law, and many will be familiar with the 2004 Asylum and Immigration Bill issues that led to what might be called being at the border of a nuclear option when it comes to how the courts will react to laws that threaten the rule of law. And of course, in the Jackson case, we had the intimation that in extreme circumstances, the highest courts might consider that it's not their position to uphold the literal meaning of legislation passed. If that's the nuclear option, if that's the catastrophe, where are we right now on the doomsday clock? How many minutes to midnight are we now, and what are you looking out for as the warning signs that the minute hand might be nearing 12 o'clock?
I was just about to say help. I mean, what I think is interesting in the current, in the current state that we find ourselves in as a nation, and some of what I alluded to in my speech, is the current tension in terms of what some of the proposals in respect, or actually in terms of some of the legislation that we are seeing going through Parliament currently. And I was discussing this very point earlier today in terms of there's lots of good things, or somebody I think described I always get the name of this bill incorrect, so forgive me. Police sentencing and crimes courts bill. Well, anyway, yeah, I'm hearing yes. But somebody said it's a bit like Christmas. It just keeps giving. In terms of there's some really good things in that bill, but there's some really things that are not so good that really do go too far and probably entrench on some of our absolute rights. So the Law Society has a number of concerns, particularly around remote juries. We don't favour those for a number of reasons, namely because our view is that the integrity of that process, being able to be judged by your peers is a fundamental tenet of our democracy. And that means being able to judge somebody's body language, facial expression, and so forth and so forth. So there is a tension in terms of what is proposed, what is currently making its way through Parliament, and what will end up ultimately on our statute books. And we will continue to advocate to ensure that the public, as I said in my speech, that the public are aware of what's going on. And I think the public increasingly have to be aware and hold government to account, because there are some proposals that are going too far. And so I think we all need to be awake to ensure that that hand that is ticking close to midnight is not going to catch us all unawares. Because there are concerning parts of the different proposals for legislation that is going through currently. I think did you want to say anything on that? Yeah.
The two questions alone demonstrated what an impressive speech this was, both as to the depth and breadth of the topic, the rule of law, which is at the very core of our justice system. For those of us who are members of this inn, how very good to hear those 8 principles of Lord Bingham. There's his portrait there, a former master of the inn. Madam President, it was so good to hear such a clear exposition of the principles of the rule of law, the analysis, and very interesting to hear of that public review that was carried out. Fascinating to hear the responses of the public. We are indebted to you and will remember what has been said tonight. Thank you very much indeed.